law, general agreement on tariff and trade, law and human rights, international trade dispute settlement, and law of the seas. He previously worked as a trade lawyer for the Indonesia Trade Assistance Project under the auspices of the United States Agency for International Development, which cover a range of trade law matters, including dispute settlement, trade remedies, free trade agreements, and domestic trade issues related to the World Trade Organization. As a lecturer for law and human rights, he gives various training on international humanitarian law, human rights to police, judges, attorneys, and prison guards. Without any further ado, I present to you our moderator. Please welcome Mr. Hadi Rahmat Purnama. The floor is yours.
Hello, good afternoon, ladies and gentlemen, distinguished guests. This will be the hardest thing to do, especially after lunch. And Indonesians' food tends to make people sleepy because a lot of carbohydrate. However, I will be helped by our panelists, distinguished panelists, that will help me to make up your day, especially on the issues of how we've revisiting the Bandung spirit and outlook for international law from Asian perspective. So I will invite Professor Anne Orford to the stage. She is a professor and Michael D. Kirby Chair of International Law at Melbourne Law School, and visiting Professor of Law at Harvard Law School. She researches and teaches in the area of international law, international dispute settlement, international economic law, and climate change. She is a member of the Permanent Court of Arbitration at Fellow of the Academy of the Social Science in Australia. In the past, Presidents of Australian and New Zealand Society of International Law. She is visiting legal fellow at the Australian Department of Foreign Affairs and Trade, and has been international expert advisor on climate change and international law to the Pacific Island Forum. So that's Professor Anne Orford. And then the second panelist is Professor Luis Eslava. He is teach and research in the area of international law, international development, international legal theory and history, international human rights law, comparative public law, anthropology of international law, global governance, global politics, economy, and urban law and politics. He is also a member of the Network Third World Approach to International Law, or TWIL. His work focuses on the multiple ways in which international norm, aspirations, and institutional practices. He also research chair in the international at Lathrop Law School, Lathrop University, and senior fellow at the Melbourne Law School, international professor at Universidad Externado de Colombia, I hope I pronounce it right, and core members of teaching fully faculty and Institute of Global Law and Policy, Harvard Law School. And then the third one is Professor Liu Huawen. Please, I invite you to the stage. Professor Liu Huawen is the Deputy Director and Professor of the Institute of International Law Institute, Chinese Academy of Social Science. And he also the director of the Center for Human Rights Studies at the Chinese Academy of Social Science. And then he also a member of the UN Committee Against Torture. So, and then the last one that will be joined online with us is Ambassador Arif Havas Oegroseno. He is Ambassador of Republic of Indonesia to to the Federal Republic of Germany since 2018. And previously, he was the Deputy Minister of Maritime Sovereignty Coordinating Minister for Maritime Affairs Republic of Indonesia. And he obtained his LLB from Universitas Diponegoro, Semarang, and Indonesia, and his LL.M for Harvard University class 1992. He contributed a chapter to Prof. Eslava co-edited book and volume on Bandung Conference. So in these panels, we will look at the Bandung spirit and how this Bandung spirit can have the answer to the challenges that face by international community and also in international law. Without further ado, so I will give the first opportunity to Professor N. Orford, and followed by Professor Luis Eslava, and then by Professor Liu Huawen. And then the last one will joining us from the Germany is Ambassador Arif Havas Oegroseno. So the floor is yours.
Well, many thanks for that introduction. I'm also extremely grateful to the organizers of the conference for the invitation to participate on this panel, and to our hosts for their very generous hospitality. I'm so glad they decided to spend the opening day here in Bandung. I think I've already learnt more about Bandung walking around the museum than I have really in all the reading I did in preparing for today. It's also an honour to share this panel with such distinguished speakers, and it's a particular pleasure to share the panel with Professor Eslava, who was once my doctoral student and from whom I've learnt such a great deal over the many years we've worked together on the questions that we're looking at in this conference. So history is a site of struggle over the meaning of international law, and the history of the Bandung Conference is no exception. We've been invited, all of us, to become part of that struggle for the meaning of the Bandung spirit from the Asian perspective today. And as we know, this idea of a Bandung spirit emerged alongside the conference in 1955. But almost from the beginning, what that spirit was and what it means was contested. So some details are uncontroversial. We saw a number of them in the museum today. We know, for example, that from April the 18th to the 24th, 1955, leaders from 29 states, 23 of them from Asia, attended the Asian African Conference. We know those states represented approximately 2/3 of the world's population, a figure that was frequently cited in conference speeches. We know that the conference produced a final communique, that it was drafted by the 3 political, economic and cultural committees, and then that's about the last we are completely sure about. There's even been lively debate over who attended, though I feel that was answered for us today in terms of which delegates were present. I was interested to see there were 2 Australian observers, and I'm going to go home and find out who they were and what they were doing here. Indeed, the debate over Bandung's meaning began even before the conference was formally convened, and we're told that by Luis and his co-editors of the collection on Bandung and international law that was published a few years ago. But perhaps the most heated ongoing debate has been about the Bandung spirit, and we hear it being said to express numerous things. So, for instance, it's said to express anti-imperialism, the principles of self-determination and non-intervention, sovereign equality. It expresses non-alignment, or does it? It expresses a new international economic order, or was it not so new? It represents Asian-African solidarity. In the US version, it represented a global race consciousness in the report published by Richard Wright a few months after the conference. More broadly, in the words of Mustafa Kemal Pasha, Bandung represents the promise of perpetual decolonization. So much discussion in historically oriented scholarship has discounted many of those suggestions as myths and suggested that they need to be corrected by empiricist historical work. And in those accounts, myths are bad, and empiricist history is good. Myths are a form of depoliticized speech, or maybe they're hyper-politicized speech, just propaganda. But either way, they need to be corrected by rational, scientific, disenchanted thinking about history. Well, I've argued elsewhere that myths are not something we can or simply should dismiss, and mythologizing isn't inevitably a bad thing. The more interesting question for me is what work a myth is doing and for whom. So my interest here is particularly to explore the work that myths associated with the spirit of Bandung do. Myths about anti-imperialism and the assertion of independence, what they do at particular moments in and through international law. And to cite the introduction by Luis and his co-authors again, the historical embellishments and political law that have been attached to Bandung are important windows into understanding its significance for the global order, and in particular for international law, because international law, like all law, has always been laden with myth. So here I want to think about the work that this Bandung spirit did for international law in two moments. First, in 1955, the moment of decolonization in which the conference took place, and now the work that the spirit, the myth of Bandung is doing today. So if we look back to 1955, let me focus on four aspects of this myth that I think are interesting for us today. The first is the principle of anti-imperialism, the ideas of sovereign equality, self-determination, non-intervention. And so many see this as the key spirit of Bandung. We can see this reflected in many aspects of the final communique that were drafted by the political committee. So the references to the rights of peoples and nations to self-determination, the evils arising from the subjection of peoples to alien subjugation and exploitation, and the reference in that communique, which finds its way straight into Resolution 1514 some years later, the powerful affirmation that the subjection of peoples to alien subjugation, domination and exploitation constitutes a denial of fundamental human rights, is contrary to the UN Charter and an impediment to peace and cooperation. The conference also declared its support for the cause of freedom and independence of all peoples. I'll come back to that language of peoples, stressing its support of the rights of the Arab people of Palestine, calling for the admission of all qualified states to the UN, and specifically naming Cambodia, then Ceylon, Japan, Jordan, Libya, Nepal, and a unified Vietnam, and calling for disarmament and prohibition of nuclear weapons. And the 10 principles which we heard performed this morning included respect for the sovereignty and territorial integrity of all nations, recognition of equality of all races and all nations large and small, the principle of non-intervention, abstention from the use of arrangements of collective self-defense to serve the interests of big powers, and settlement of disputes by peaceful means. So we can, and scholars have, traced a straight line from those normative ideas through to General Assembly Resolution 1514, adopted in 1960, the Declaration on the Granting of Independence to Colonial Countries and Peoples, which fundamentally reshaped our thinking about sovereignty. But in the aftermath of Bandung, it gradually became clear that the language of sovereignty, of non-intervention and of self-determination would leave a complicated legacy. So those principles can lead in different directions, as can the desire to channel the energies unleashed by decolonisation. So the repeated references in the leaders' speeches to the revolutionary yearnings of the 1.4 billion people who live in Asia and Africa was directed in two ways. So it was shoring up the authority of those leaders against the West, but it was also shoring up their authority over the 1.4 billion people they would now govern. And the appeals to sovereignty and non-intervention also served to legitimise those acting in the name of the state and delegitimise other forms of transnational solidarity. So that could be revolutionary if the forms of transnational networks you wanted to disrupt were colonial, but it could also serve a conservative and even authoritarian agenda by functioning to protect existing power structures from forces characterised as external and demanding politics be mediated solely through the nation state. So the language of sovereignty and intervention draws the line between what or who is legitimately included within the struggle to govern or shape a political community and who is excluded. That tension can also be seen in the second aspect of the spirit of Bandung, the notion of non-alignment. And there's been a vocal debate about whether Bandung really stands for non-alignment. So Robert Vitalis has vehemently criticised this claim, arguing that Bandung, in its composition and decisions, was the antithesis of non-alignment. But Judge Benuna has argued that the Bandung Conference is the basis for the non-aligned movement. And as that debate suggests, the project and principle of non-alignment has a complicated relationship with the legacy of Bandung, not least because most of the countries, the majority of the countries were aligned, and many of them aligned with the US. Nonetheless, the Bandung Conference is seen as at least one influence upon the subsequent emergence of the non-aligned movement, which was founded at a conference of heads of states representing 25 predominantly Asian and African states in Belgrade in 1961. And that idea of non-alignment seems to capture the revolutionary spirit of resistance to or refusal of imposed unities and alignments, often seen as part of the Bandung spirit. So third, the dream of self-rule was also an economic one, and the Economic Committee of Bandung, led by Muhammad Hatta, took up that story. The final communique provided an alternative economic vision of the future of international order. And here we can think about the trajectory that begins with the drafting of the proposed International Trade Organization, on which states of the Global South played an important role, and the resulting final version of that charter involved and included many of the elements that would be eventually included in the resolutions establishing a new international economic order. The final communique of Bandung took up a number of the ideas set out in the Havana Charter, albeit with a faith in the project of developmentalism and reform of the institutions of the Bretton Woods that we might see today as misplaced. And yet again, the legacy here is ambivalent. The task facing the leaders gathered at Bandung and the peoples they represented would prove a far more complicated one than those declarations that were somehow both idealistic and technocratic seemed to envisage. The material promises made by national liberation movements, faced with decades, if not centuries, of predatory colonial exploitation, left the leaders of newly independent states scrambling to address demands for employment, education, healthcare, access to water and energy that decolonisation was meant to offer. And while former colonies saw independence as the moment at which they could transition beyond being a source of raw materials and cheap labour for their colonisers, the urgent need to realise the promises of modernity meant that even revolutionary independence leaders began to believe the only available answer was to become dependent upon capital to address the economic needs of their societies. And finally, we could think about the Bandung spirit more abstractly as involving a contribution to innovation or renovation. The post-independence generation of third world international lawyers, while committed to international law, argued that refusing to think about when and how inherited law was inadequate could lead to injustice. And we might think here of the 1970 series of lectures by the Indian jurist R.P. Anand, published under the title New States and International Law, where he argued that in a world and age of revolutionary change, of cataclysmic proportions, it's essential to reassess the validity of the present legal order. It's not possible to imprison this process of legal change in legal traditions which have lost the breath of life. Or we could think of the opening comments by Judge Amoon in his judgment in Barcelona Traction the same year. The legal questions raised by the case which has been submitted to the court cannot but feel the effects of this great renovating moment in international law. So the last aspect of the Bandung spirit I wanted to take up was this idea of renovation or innovation, which we see informing many of the things that followed Resolution 1514, but also the new international economic order, the creation of UNCTAD, the negotiation of the Law of the Sea Convention. So what might it mean to revisit those four aspects of the Bandung spirit today from an Asian perspective? So in asking that and following the call of this conference invitation, I don't want to suggest or to idealise the Asian perspective. That perspective shouldn't be idealised, and nor indeed is it unified. It wasn't in 1955 and it isn't today. International politics is not a morality tale of good and evil. But on the other hand, in this multipolar era, I do want to suggest the significance of powerful voices and political forces situated outside the North Atlantic, and to highlight some aspects of the perspective and experience offered by representatives of states and civil society groups from this region. A pragmatic approach about managing rivalries of great powers, an openness to different perspectives and legal systems, a commitment to pluralism on its best days, solidarity, and engagement with regional partners as a way of achieving peace rather than militarism. So here I'll just mention some randomly chosen examples of ways in which I think those four aspects of the Bandung spirit are resonant for this region today and for many of the conversations that the paper titles promise over the next 2 days. So the first is the notion of anti-imperial internationalism, self-determination and non-intervention. And here the most powerful recent legacy, of course, is taking up Resolution 1514 in the Chagos Island Advisory Opinion, where the court, against the arguments of the US and the UK, and I'm embarrassed to say Australia, argued that we saw with Resolution 1514 the crystallisation of a right to self-determination, an erga omnes right, which all other states must recognise, very much adopting and affirming the language out of Bandung. That has enormous implications for the last colonies and non-self-governing territories in this region, with flow-on implications for the control over vast EEZs and the approach to military bases in the region. Yet, as I've already mentioned, the language of sovereign equality and non-intervention can also be wielded as a way of stifling internal dissent that's somehow seen as disruptive of status projects or illegitimate due to foreign influence. So we might then want to think about whether and how today's statist version of international law can make space for forms of anti-imperialist internationalism that don't always centre the state. Second, in relation to the legacy of non-alignment, the Asia-Pacific, like much of the world, is again facing a moment which requires skill in balancing rival hegemons, from which we might find ourselves with much to learn from the tradition of non-alignment. It's a moment of pressure that many, I think, states in the region are feeling to take sides in relation or in alignment with the US and China. Under the current US administration, we see increasing stress on strengthening alliances in the region, and yet there's not unanimous support for either the US or China. And I think the resolutions in relation to Ukraine are, of course, an example of this. The March 2nd, 2022 resolution that deplored the aggression against Ukraine saw 35 states abstaining and 5 countries voting against, half of those countries being from Africa. On April the 7th, in the subsequent General Assembly vote to suspend Russia from the Human Rights Council, dozens of countries abstained. So the resolution passed with 93 nations in favour, 24 against and 58 abstaining, but those abstaining included much of Asia and Latin America. And while the strongest sanctions regime ever seen has been imposed by the US, the UK, Canada, South Korea, Switzerland, Japan, Australia, New Zealand, Taiwan, Singapore and the EU, very few nations beyond that coalition have chosen to take part. On the contrary, many of the world's largest nations and many from this region have refused to join in. Most of Southeast Asia and the Pacific want to avoid being caught up again in a great power game. And again, we might think about the relevance of Bandung here. As non-aligned states have long insisted, the starting point for resisting oppressive forms of regional ordering remains old-fashioned mechanisms such as supporting the peaceful settlement of disputes, creating increased pressure for disarmament, resisting the creation and maintenance of foreign military bases, establishing nuclear-free zones, resisting the attempt to expand the legal grounds for resorting to force, and committing to peaceful use of the world's oceans. Not really incredibly revolutionary, but they would be if they were put into play. Third, we're now in another period of renovation in the field of international economic law, broadly conceived. The conditions for the current moment of change include the shifting politics resulting from the decline of the US empire, the rise of rival economic and security powers, particularly China, and the major systemic shock of climate change. I won't say too much more about that, partly because Louise is going to pick up on this topic and partly because so many of you have fabulous papers addressing this over the next 2 days. But let me just say that we are seeing, I think, in this context, both the US and in some ways the EU beginning to think their commitment to WTO multilateralism, for instance. We're seeing a rethinking of ISDS, and the race is on to find an ideological framework that will justify the new legal architecture that the US and now the EU are seeking to constitute in place of multilateralism. But to date, it's only powerful players that are being invited to rewrite the rules of the global trading regime, as demonstrated by the approach taken to negotiating a temporary waiver of provisions of TRIPS in the context of the COVID pandemic, the growing use of climate clubs as a means of addressing decarbonisation of the economy, and the turn to plurilateral negotiations at the WTO as a way for more powerful members to move forward on issues such as services and investment liberalisation. In contrast, states from the global south have not yet been able to reclaim the critical policy space they yielded in joining the WTO. And if the US and the EU are serious about rethinking international economic law to make space for regulatory autonomy, increasing democratic control of economic matters, and rethinking the utility of trade agreements, they must welcome other states and actors taking the same approach. And finally, I think the spirit of innovation and renovation is clearly present throughout the region. We could think of the leading role that states from the region have taken for decades in relation to the law of the sea, from Singapore's chairing of UNCLOS 3 and the BBNJ negotiations, through the use of the law of the sea dispute settlement mechanisms in a number of really dug-in disputes across the region, including, for instance, between Timor-Leste and Australia. We can think of the leadership in this region in climate change and climate litigation. It will be the centre of transition by necessity, but we've seen states from the region push both in relation to the ICJ advisory opinion and now in relation to the ITLOS advisory opinion. In terms of sea level rise, we can think of the work of the Pacific Island Forum, both on rethinking the approach to the stability of maritime zones and boundaries, and also now the groundbreaking work that PIF is doing on the implications of sea level rise for statehood and displaced persons. I was honoured to take part in the PIF regional conference on that topic in March, and in my view that is the future of statehood is being written in the Pacific. And finally, we might think of the role being played by this region in relation to nuclear weapons. And I mention that today because this week is the 78th anniversary of the bombing of Japan. 78 years ago on Sunday, the US dropped the atomic bomb on the city of Hiroshima, and tomorrow will be 78 years since the US dropped the second bomb on Nagasaki. As those who live in the region know only too well, the Pacific remained the testing ground of choice for nuclear weapons for decades. My students know a lot about that because they learn about that history from studying the Rainbow Warrior arbitration, where they learn about the pleas of necessity and force majeure. They studied the nuclear test cases, where they learn about the legal status of international unilateral declarations and the emergence of principles such as intergenerational equity from the extraordinary dissents by Judge Weeramantry. And they studied the Marshall Islands claims against nuclear weapon states, where they learn to think formalistically about whether there's a dispute between parties. But all those cases were brought by states in the region, or revealed the tendency of courts and tribunals to privilege statist interests in addressing security. And we also see states in this region leading in this area in terms of negotiations for the Treaty on the Prohibition of Nuclear Weapons, where almost a third of the states' parties are from Asia Pacific, and Indonesia is poised to become the 20th party, may have, in the past day or so. Anyway, I gather that is we're soon to find out. So while Australia hasn't signed or ratified the TPNW, I'm pleased to say that in October 2022, Australia for the first time abstained from voting on the annual General Assembly resolution that welcomes the adoption of the TPNW. That was a step forward from our voting against it in every vote until then. So to conclude, studying the Bandung Conference doesn't, I think, leave us with a program for action. Rather, the legacy its participants leave those of us standing in the ruins of decolonisation is their ability to begin again, their perseverance, their innovation and their fighting Bandung spirit. Thanks.
Yes, thank you very much, Professor and Orford. It's very interesting how CD delivers about four aspects that need to revisit it in the Bandung spirits, whether this aspect will be the myth and how the reality now facing by the countries around the world, especially from the Asia and the Africa. And one most important thing is about the anti-colonialisms and imperialisms, how it affect the international law, and about the non-aligned movements, and also the economic alternative that need to be seen again, maybe to be reviewed, and also how the innovations and renovations of legal order in international law. So the next panelist will be delivered by Professor Luis Eslava, and the floor is yours.
Thank you so much for the introduction. Thank you for the organizers for inviting me. Anne was saying just before that she feels very honored to be here with me, one of her former PhD students. Now you can imagine how terrified I am here giving this talk after Anne, my supervisor, is still. I thought that what I could do is to reflect on an aspect of the Bandung Conference that remains, for me at least, extremely important, if not critical, when we think about the conference itself and when we think about international law today, especially in terms of what's coming next in a world on the brink of, or if not already, in a process of massive extinctions, environmental crisis, and mounting tensions globally. And so what I will, oopsie, that's not, shouldn't be there. So the trajectory that I want to trace with you is something that was very present in 1955 here in Bandung, when leaders of Asia and Africa came for the first time, explicitly not inviting what now we call global North nations, and was the question about the global distribution of resources, okay? Very plainly, one of the key concerns of the conference was how to share the pie, okay? A pie that had been maldistributed, there had been a process of legal misallocation for a long time. And the concern was how to reorganize the distribution of resources in order to build a future, not just, but a common future, okay? If we think about Bandung along these lines, we can understand how revolutionary was what happened here 60-some years ago. For us, when we put together the collection that have been mentioned before, this was one of the main concerns. This is a book that we came out in 2017 that my colleagues Michael Fakri and Basuki Nisia put together, and we managed to bring a fantastic group of 40 or so authors to reflect critically on the conference. And for us, this concern that I just mentioned about the global distribution of resources was key for an element of the subtitle that sometimes escapes because it seems just a marketing line, this idea of pending futures, okay? So there was, at the conference, there was a discussion about what future we wanted, okay? And we believed together with Michael Ambasuki and with many of the authors, that that's a future that we still can attain if we work towards it. Now, when we think about this idea of painting futures and that kind of looking forwardness of the conference, it can be characterized as a myth. It can be characterized as innocent. It can be characterized as an anachronistic infantilization of those leaders. Now we assign them kind of a revolutionary spirit, a heroic spirit that they didn't have. Okay, but it was not the case. You go and read the final communique with attention. You realize that kind of aspirations that attempt to build a different future was very much anchored in the realities that they were experienced. So there was no an innocent speculations about how make a better world for everyone, all happy-chappy. They were critical about the realities and trying to think about how to move forward. Now, this is important when we think about Bandung. We need to remember that behind perhaps the veneer that we still, I at least, fetishize, and I am extremely excited to be for the first time in Bandung myself and staying in this hotel. Behind the diorama that we saw today in the museum, there was really important doctrinal, political, and ethical lessons that came out of the conference in 1955. So what I will try to do in the remaining minutes of my intervention is first try to locate Bandung within the history of international law in just a few minutes. Then I want to outline very quickly what was at stake in terms of the global distribution of resources during the conference. And finally, what's happening in Bandung today when we think about that distribution. So, as we all know, Bandung is important because it was the first explicit non-white international conference. There have been many previous gatherings of political heads of Asia, and Africa, and obviously there was similar exercises in Latin America. But the Bandung Conference was the first one that was called under international law after the Second World War without inviting, let's not talk in racial terms, better talking geopolitical terms, global north of what we now call global nations. And this is important because if this was the Bandung map, this was the real map at that time. So this is the colonial, the international map, the global map, the colonial map in 1945. Okay, the large majority of the world was still under colonial domination or in a position of colonial control. So again, if we think about Bandung in these things, in these terms, it is very clear that what happened here, it was just not a simply sanitized international law meeting. It was really a challenge to a factual way of legally ordering the world. As a side footnote, in the Bandung final declaration, the leaders gathering here argue that the Charter and the Universal Declaration of Human Rights have made colonialism illegal, but that's not a fact. That's an interpretation that they're trying to advance. Neither the Charter nor the Declaration of Human Rights made colonialism illegal, okay, because of the de facto recognized and was other ways of organizing the world apart from the national state form. Then only after 1960 became legally the only form, or at least the assumed only form that we organize the planet. So it is for this kind of potentiality that international law, the potentiality of Bandung Conference and what it meant in terms of the actual organization of the planet at that time, that Bandung by itself unleashed a new tradition in international law. a tradition that we have already kind of repeated today several times in this panel, and today we heard about in our visit to the museum. So there's the Bandung Conference, the Non-Aligned Movement, the Tricontinental Conference, the formation, the G77, extremely important alongside the formation of UNCTAD, the new international economic order, and many people will extend it to the right to development in 1986. Now, what was doing or was happening then, again thinking in terms of the value of Bandung in international law, is that they were tapping themselves into a history already outlined for them, the Westphalian history and the ideas about how we should organize the planet and the universalization of a particular form of organizing the planet that was emerged from Europe in the 17th century. And instead, what they did was what we could say uncover the colonial underbelly of international law. And the declaration is very clear about that. So there's an international legal order that have been contested. We are now part of it, but colonialism remains there, and we need to outlaw it. In so doing, they basically were advancing a legal argument in order to give tools, in order to give force to a political contestation on the ground, particularly in Africa. Okay, and in 1955, what happened here was giving an armory of new resources to what then came to be known as the decolonization movement that began in 1955 and concluded around 1975. Now, importantly, they were not only concerned about colonialism in the past, but there was also concern about neocolonialism at that moment. But for Nkrumah, a few years later, was the most pervasive form of colonialism, okay, and one that was still in operation and will continue, we'll say, till today. I was very interested to read, to discover that in the inaugural speech by President Sukarno in 1955, he mentioned about neocolonialism when we suggested that inequality, domestic inequality, was a form of colonialism, and all forms of the colonialism had to be eradicated. So a lesson that we should remember today. So when we think about the world today, okay, this world that came to be produced by these processes, both the Westphalian processes and the Bandungian processes, the world is more Bandungian than Westphalian, okay? The world is more Bandungian than Westphalian. And this is an argument that we try to make kind of in a doctrinal sense in that collection. But methodologically, Bandung also inaugurated other way of thinking about international law. Instead of thinking international law in terms of a linear progression of international legal developments, Bandung inaugurated a way of thinking about international law and actually practice international law that could be called something more of a contrapunctual way, okay? A way of doing and thinking about international law in conversation, in relation to hegemonic or other ways of thinking about our field. I think this is very important for kind of academics of international law, but also for practitioners of international law. So very quickly, the second part here is about, what was at stake, okay, in terms of the global distribution of resources. And what was at stake was the factors of production, the good old land, capital, and labor, okay? And then if you read the declaration and the conversation, especially of the Economic Committee, was all about, how we can make sure that our land is our land and we can use it. The capital that is under the control of a few is distributed more fairly. And secondly, and finally, how labor can be mobilized effectively in order to add value, okay, to the products that we produce in the global south. But they also talk about what is known in political economy, a kind of a second tier of factors of production in the context of Bandung: technology, trade, and culture, okay? as we all know, there was a culture committee, and normally we tend to think about the culture committee of the Bandung conference as where folklore happens, okay, when people dress up in a funny way and then all trying to argue that they have a distinctive cultural character. But they were more sophisticated at that. Oops. That what they were thinking about culture, it was, we live in a world in which differentiation is important, and we need to recognize this differentiation, and that could be an added value if we think in economic terms. Now, in so doing, in claiming to redistribute these resources more fairly, what they were trying to do is to move from global north control of those resources to what Professor Angie reminded us in the contribution to the Bandung collection, the recognition of global South developmental sovereignty. Okay, so from global North control of the resources to something that we should understand as developmental sovereignty, and in so doing, for an order in which the resources were organized according to force, brute force, because that's colonialism, plus other things, to a world organized around cooperation. Okay, so cooperation becomes much more interesting when we think in these terms. Now, finally, what has happened with this today is, as Anne was trying to remind us in what has happened with the trajectories of the line of action that emerging from Bandung, is that we live in a different planet, and for me, a planet in which the tool set that existed at that point in 1955 doesn't exist anymore, while it has come to be severely contested. Okay, so for me, that toolbox is composed of three things. One, tools coming from public international law, tools coming from international economic law, and tools coming from international human rights law. At that point, 1955, public international law gave to countries participating in the conference this a kind of a much more stronger version of sovereignty or self-determination. Okay, it was denied for many, but when it was advanced as a legal argument, had a really power and weight that is no longer the case. In terms of international economic law, it gave to countries gathered here this idea of development understood as modernization, more specifically full employment and industrialization. And it was it's hard to remember that, but it seemed at that point that it was a right for you to industrialize. It was for you. It was a right that you have to aspire to full employment. Okay. And in terms of, this moves by itself, sorry. And in terms of international human rights law, there was a more collective or collectivist idea of use of human rights. Here, I think Jessica, I don't know where Jessica White is, colleague, she has written very insightfully about how when we think about human rights at that time, we need to remember that self-determination was understood as a human right. And self-determination is a collective right. Now, this tool set has come to be contested in terms of public international law. These ideas of self-determination came to be replaced by ideas of the good old globalization. International economic law, development became articulated or re-articulated through the idea of free trade. Nowadays, taking the form of global value chains and automation as one of the aspirations of development, which is opposite to full employment, diametrically opposite to full employment. And in international human rights law is a much more individual idea of rights than we have today. Now, this is important because as the tool set of that the Bandungians, the original Bandungians had, came to be replaced by this new tool set, the world changed effectively. Okay, so it is not surprising that a few years later, or a couple of decades later after the conference, the world stopped to be thought in terms of first, second, and third world. And what became increasingly clear was that was much more organized according to a bipolar order than was going to present harder challenges to overcome. This is the famous Willy Brandt report that generated what is now we know as clearly as the global north and the global south. Now, this is just not simply a line drawn on the map. This is also a line that has had a really important effects in terms of how distributed resources have come to be distributed, and increasingly even more mal-distributed. This graph that I brought for you here is from Jason Hickel, and where you can say that when we think in terms of GDP per capita, the global north today accumulates many times more of that GDP than global south nations. Similarly, as the international set has come to be contested and challenged and replaced for globalization, free trade, and individual human rights, what we see on the ground is that in terms of who has the control of the main factors of production today are the usual suspects. So here is one of the most updated versions of how value moves in what we understand as the global value chains that are presented as kind of lines, many lines drawn on the map. But when we gave weight to the different elements of global value chains, the ones that have the highest control of those chains are United States, Germany, France, Netherlands, Belgium, United Kingdom, and China, a new player definitely in the game today. And we also know that as we have moved away from Bandung and the tool set that they have, the enormous growth of the global economy has increasingly come in the controls of the hands of a few. Here I put this interesting graph on using Google Data Explorer. And so I try to compare, GDP distribution, comparing United States, United Kingdom, France, and Russia and China, the P5, the permanent members of the Security Council, and some of the key participants of the Bandung conference. And what you can see here is in terms of GDP per capita in these different countries, the Bandung powers remain pretty much in the same place when the others are far ahead in the game. The argument here is that international law has to do something with about that. And we know that this is something that happens collectively at the level of national states, that maldistribution, but also has a much more granular maldistributional level. The 22 richest men in the planet have more wealth than all the women in Africa. Just one example that Oxfam has mobilized recently to call attention to the global inequality, which according to Sukarno is a form of colonialism. And we also know that this maldistribution of resources piggybacks on still ongoing forms of colonialism. So here's one of the most updated map of overseas territories and dependence of the world. And of those dependencies and overseas territories, most of them are under control of France and the United Kingdom. I think 34 out of 48, I think. And many of these overseas territories and dependencies are used as fiscal paradises where the super rich kept the money safe and away from any form of sovereign control by anyone, actually. And this is also has been, this order that I just described here, this very sad order, is walled now. It is protected by a regime or border controls that didn't exist by the time of Bandung. So this is one of the most recent drawn maps called the World that shows how the global north today is just not simply a line on the map. It is actually a big world that encircles the global north and keep it away from the global south. Very little countries in the global south can do to contest that world. And then forms of representations that in the Bandung conference we thought that we could have challenged, now today are also outside our control. Here's one of the recent graphs that have been produced about how artificial intelligence and algorithms think about the world, and they think about the world through the lenses of the global north. Again, it's very little that we can do in order to challenge the misrepresentation of realities on the ground. And nothing, obviously, that we can say here in substance about climate change and who has produced the climate crisis that we are all experiencing today, and how the climate crisis will affect more countries and peoples in the global south than in the global north. This has effects at the global level and the level or at the domestic level. In Indonesia, very quickly, Indonesia is going through a massive economic boom, good for the country, but that massive boom has a story to tell also in terms of poverty. Only 3 months ago, the World Bank released a report called Indonesian Poverty Assessment. It's extremely interesting, and the report heralds the graph that I brought for you, and it's on your right, and then it shows, perhaps you can see it there, that Indonesia is about to overcome extreme poverty. And the report does a lot to applaud that, and we definitely should be happy about that. What the report doesn't necessarily highlight is that it's still a large proportion of the population in Indonesia lives with less than $5.5 US per day, which is around half of what is needed to live a dignified life in the 21st century, which is $10 US per day. Okay, and this is happening as the country increasingly is becoming internally more unequal. This is a graph of the Gini coefficient evolution of Indonesia in previous years, and it is not very far as the most unequal countries in the world, Colombia and Brazil, for example. Now, the World Bank heralds the overcoming of extreme poverty, ignores the people living with $5.5 US per day, and what it does, of course, is to still suggest the same recipe that we all know. I hope this conversation and this quick outline, schematic outline of the Bandung spirit as it materialized in terms of the global maldistribution of resources, how they try to challenges and the current challenges, help us to think in the next 2 days of the conference about the pending futures the Bandung conference try to open for us, and the fight and the new stakes of the fight that are before us today. Thank you.
Thank you very much, Professor Luis, for the presentation. It's very interesting. And then one of the points that I took that I think it's very important is how to give the alternative, especially in the international legal order, that what have been given by the Bandung spirit to give alternative to different way of seeing either the public international law or international economic order, and also about human rights. I think that's something that we need to go deeper in our parallel sessions next time. And the next presenter is Professor Liu Huawen. And without further ado, floor is yours.
Thank you, Professor Purnama. Before my PowerPoint put on screen, I would like to produce a very brief response to a small issue. And I'm from China, so Chinese scholars, we care something. And just now, Professor Orford mentioned the official stances toward the Ukraine conflict. You named Korea, Japan, Taiwan, and the EU. But for us, we feel not acceptable. For you, maybe it's a technical thing. For us, it's politically and legally important. So it's with respect, it's my expression or my own understanding. I feel honored to be here. Actually, back in 1955, uncle-in-law of my wife attended the Bandung conference. He wrote a book, and I read his memoir, and I look forward to this meeting so much. After Bandung conference was held during the past 80 years, our world has experienced a lot of changes. Just now, our second lecturer produced us different world maps. You could see today our world is so much complex, and we are facing traditional, non-traditional threats, challenges, and opportunities. And sometimes I feel we are facing a similar situation to the situation the nations were facing in 1950s. So we are at a critical moment where we go, how we go further. We need to answer the questions of the time. So today in Bandung, it's the right time and the right place to discuss the very important issue, the fate of human being of the world.
You don't have it?
I sent it yesterday to the person contacted me. No. Crystal, where is Crystal? I sent it yesterday. So before it's found, I will continue.
Okay. I would like to ask whether or not Ambassador Havas is already online or not. Maybe we can switch the sequence.
I can hear you not very good actually. The connection is not so good. But can you hear me?
Yes, Ambassador Havas. We can hear you. Maybe we can switch from Professor Liu to you, Ambassador Havas.
Should I speak now or because the voice is not so good?
We can hear you.
There is a gap in the voice.
Okay.
But can you hear me?
Yes, we can hear you clearly.
All right. So I will try to speak very slowly. So hopefully that the connection will be good in Jakarta. Well, let me first of all thanks Universitas Indonesia and ASEAN SEAL for inviting me to be present with you today. I hope I could be physically there, but you know, it's a lot of work normally near the commemorations of 17th of August here in the foreign missions. So let me start with the reality of our current geopolitical today. I've seen it very interesting development where we still have the traditional threats, the threats of aggressions that we have seen since, I would say, before the First World War and Second World War. This threat remains today, even in the 21st century. We look at the war in Ukraine as a very clear example. And secondly, we have a threat that comes from the climate issue. We have a threat that comes from disease, pandemic. We have threat that comes from the issue of climate change and energy issue, energy security. We are looking at the world today where you have different types of threats coming together at the same time. And also in different parts of the world, you are looking at, for instance, in Asia that we are talking today, is competitions between two major powers, which is United States and China. There is a big difference today in terms of the competitions and speed of competitions today, as opposed to the Second World War or after the Second World War, where we saw a competitions of ideological battle. There is two groups that offer, different ideology, communism versus liberalisms, which we don't see it anymore today. What we see is a competition of influence and alternative. For instance, you have in the old days Marshall Plan. Then you have an offer from China, for instance, on Belt and Road Initiative. You have the IMF and the bank, and then there is an alternative from China, for instance, the AIIB. So you are having this also competition in technology. One camp offer 4G, another camp offer 5G. There is a technology on, for instance, one camp banned the export of 7 nanomillimeter microchips, but other camp is already moving on the 5 nanomillimeter microchips. And all these technological advancements today are directly impacting the geopolitics. I think we have never seen the world like the world today, where in the old days, you make weapons, okay, for your deterrence. Today, people see that making weapons does not necessarily make better weapons, but making computers will make better computers. And this is where the competition lies in this time today. So competitions of economic development aids, competitions of alternative economic models, competition of technology, and at the same time we still see the problem of traditional threats of very, I would say, primitive aggressions, but at the same time we have a very high-tech, very future-oriented type of competitions. And on top of that, we have diseases, we have climate change, we have energy security, you have renewable energy, and of course you have fights over raw materials, which I think very interesting from the two previous speakers, where the Asia-Africa decides on the sovereignty of resources. In the past, there is a resolution in the UN on the sovereignty of natural resources, but I don't know when. I think professors and experts and academics could look. When did this principle which is gone and absorbed into WTO, where WTO simply says that you cannot have any more sovereignty or resources? The case is Indonesia, of course. We banned the export of raw nickel. Our major buyer was China. Our smallest buyers was EU, but EU is the loudest in complaining about the ban of export of raw materials from Indonesia. And it took us to WTO. And when we filed appeal to WTO, EU was basically angry because EU has another proposal, which is the MPIA, multi-party interim arrangement, which is actually another trend in international law, where now you have unilateralism very strong. You have unilateralism in vaccine. It comes to vaccine nationalism. You have suddenly unilateralisms coming out of WTO, where countries refuse to fix WTO, but instead of fixing WTO, they are creating an arrangement that seems to be multilateralistic, but not really multilateralistic, because the MPIA that is basically created by the EU is not international treaty as such. And there is another trend in WTO, which is very interesting, which is fragmentations of the existing international law. And WTO, I think, has been acting like Security Councils, where Security Council are making international law through decisions of the UN member of Security Council. And WTO now have a new agreement on fisheries, WTO fishery subsidies that refuse, I'm going to use a very direct word, blatantly, to include UNCLOS in the management of the ocean under the WTO, which is very interesting. I'm in the circle of international law of the sea lawyers, and I asked colleagues from around the world, do you know what's going on in WTO fishery subsidies? And they said, we don't know anything. There is not a single international law experts invited to speak in WTO on the WTO fishery subsidies. And this is a very interesting study for academics and professors, how far the WTO has digressed from UNCLOS. The new fishery subsidies in WTO that is agreed so far, one of the all coastal states are not allowed to provide any subsidies within their own EEZ. I mean, this is amazing. Yeah, we fought the Asia countries, the Asia-Africa countries, to create a new governance on the oceans for over 20 years. And we had a very well ratified international treaty, UNCLOS 1982, with the specific rules and regulations and regimes on fisheries and how the sovereign rights of countries in the EEZ are being protected. But WTO just suddenly came out with a new ruling, said, hang on guys, after 3 years, you're not allowed anymore to do any subsidy within your own waters. And nobody seems to even aware of this situation. So we have those very complicated development in the world today. Still the old style aggression exists. We have the diseases, we have the climate change, we have influence competitions, we have new technology as influence competitions, we have vaccine nationalisms, we have fragmentation within WTO, we have even new international law to be created by WTO that is against the existing international law. And Not to mention for instance, the unilateralism by European Union on deforestation agreement, and also on nickel raw material. I want to share with you that now, from the 7th of July until the 11th of August, in the middle of European summer, the EU is conducting a public consultations on how to react against Indonesian ban of nickel raw materials. And when I asked all the officials here in Germany, nobody knows what's going on because it's summertime. So this is a very interesting development within Europe situations today. Now, the question is whether the countries in Asia or expert in Asia, it's relevant. Well, I think in the terms of population, it is relevant. We are the largest if you combine all the big Asian countries. Especially looking at the energy requirements, of course. If we are looking at the health, of course, we have combined population that is very large and should be very powerful with the WHO reform. Trade, for instance, look at the G20, China, India, Indonesia, South Korea, Japan, and if you want to put Australia in the basket of Asia, then, you have, and if you put the US as part of the Asia as well, then you have, a really huge amount of trade going on within the context of Asia and Pacific. And climate change, of course, Asian countries, we have a lot of islands that are impacted directly by the climate change situations. And we still do not have positions on what are the impact of the rising sea level to baseline, for instance. What are the impact of the rising sea level to the existence of a country as a whole, for instance. So we heard some of the regional agreement in the Pacific, but we don't know yet a standard, common approach within the Asia Pacific or Asia on this particular issue. We are sitting in a very geostrategic high value location, for instance. So yes, in this context, Asia has weight, I would say, in terms of bringing our approach on international law. But I think, to be frank, within the ASEAN itself, we have diversity. We have different interests of big countries. We have different interests of regional countries in Asia. And I think this is the challenge. And I would imagine that the Asian countries are not very easy in uniting the positions and on these new challenges. But probably, as a previous speaker mentioned, we could maintain the existing order of international law by once again restating the importance of non-interventions, non-aggressions, unilateralisms, but also at the same time academics and countries and professors in Asia could also look at different challenges and try to find out some kind of a relevant regional mechanism within Asia that would become an international law in the future, for instance, in the area of health, in the area of energy, in the area of climate change. These are the three, I believe, that can unite different interests in Asia Pacific. And of course, hopefully in the area of trade, especially in regards to the fixing the WTO today, and also with regard to this a very unfortunate new trends in WTO, where they are making new agreement with complete disregard of the existing international treaty. So I will close by saying that I had a very interesting discussion with a very high level um, experts, officials, member of cabinet in German government. And one of the member of the cabinet asked me and other colleague from Africa a very pertinent question and very surprising question, especially coming from the Germans, whether or not, according to Indonesia and other African countries, that the Bandung principle is still relevant today. To be frank, I didn't know the answer at the time. And I asked my German colleague, what do you think? And surprisingly, in the circle in the German government, that the principle that the Asia Africa offered, the Bandung principle, actually is even more relevant today, because according to them, this principle provides what they call strategic independence vis-a-vis different powers at that time. Now today, strategic independence itself does not necessarily mean fighting or navigating between ideological blocks, but I think the threat remains the same. Competition of big powers remain the same. So this is why strategic independence is still very, very important within the context of Asia Africa. And I think today is even more relevant. But I think also at the same time, the element of cooperation where we can find element of collaboration of different competing powers, I think should also be an aspect where Asia Africa and for Asia could also have a look at it much more deeply. So once again, thank you very much for the invitation. I can only give you some of my observation here in Europe, how it is that countries in Europe are seeing themselves today. Very unfortunate that we look at the Ukraine war today. 21st century, the building trenches similar to what they had, from the mid-century to the Second World War. Somewhere in Asia. Thank you.
Thank you very much, Ambassador Havas, for very interesting presentations, especially how the Bandung spirit and also what came out from Bandung conference is still very relevant today. And we also facing traditional threat and also a new threat which become very complicated. Next, I will give it to Professor Liu. I hope the PowerPoint is ready. Okay. Yes, the floor is yours, finally.
Thank you, Professor Purnama, and thank you, technical friends, to help, and thank for all of you for your patience. So here in lobby of this hotel, you could see the book, the Golden Book. So I remember that Professor Manfred Nowak quoted the Golden Rule in his book, Introduction to Human Rights Regime. The Golden Rule is do not do other persons the way you do not like other persons do upon you. And so that's the very basis, the basic wisdom reflected by different civilization, cultures, religions. And here we see the Golden Book, not only because of the names, the signatures on the book, but also the Golden Rule reflected by Bandung conference. All of us, we excitedly come to Indonesia, and we see very soon Indonesia will celebrate the 78th anniversary of the independence. It's quite a big event. I would like to join very big festival. Yes, after end of Second World War, 1945, the national liberation movements in Asia and Africa advanced rapidly. And in the year 1945, Philippines, Burma won national independence, and the Republic of Indonesia and the Democratic Republic of Vietnam were established. Palestinian and India gained independence in 1947, and the People's Republic of China was born in 1949. However, the reign of colonialism in Asia and Africa didn't really come to an end. The situation then was uncertain, complex, and dangerous. Just now I said that even today we see uncertainties and the threats to peace, development, and human rights. In August 1953, the Prime Minister of Indonesia proposed the idea of convening the Bandung Conference. So I see Asian African states could be proud of Bandung Conference, and Indonesia could be prouder because you, together with the other 4 countries, to initiate the very important conference. And the result, the Bandung Conference took place here from 18 to 24 April 1955. It reached a consensus on cooperation between peoples of Asia and Africa to fight against imperialism and colonialism, seek common ground while reserving differences, and seek common development, establish the Bandung spirit of solidarity, friendship, and cooperation, and put forward the 10 principles of Asian African Conference. The Bandung Conference was the first large-scale international meeting of Asian and African countries to address issues of vital interest to the peoples of Asia and Africa on their own without the involvement of colonial powers. The successful convening of the Bandung Conference demonstrated the Asian African region had been or was being freed from colonial oppression. And President Sukarno of Indonesia revealed in his opening address to Bandung Conference, entitled "Let a New Asia and a New Africa Be Born." As I quote, the peoples are no longer victims of colonialism. They are no longer the tools of others and the playings of forces they cannot influence. Today, you are representatives of free peoples, peoples with a different identity and place in the world. Back at that time, actually, the situation is complex, and there some people raised the problem about communism, and Chinese Premier Zhou Enlai made it clear from the outset the Chinese delegation is here to seek a common ground, not to establish divergence. He said that there is a basis for seeking common ground. Zhou Enlai made clear his position of seeking common ground while reserving differences. He pointed out that the purpose of China's participation in the conference was not to dispute, but to seek unity and cooperation among nations. At the same time, China did not come to seek differences, but to seek understanding among nations. Prior to Bandung Conference, China, India, Myanmar had jointly put forward the 5 principles of peaceful coexistence, namely mutual respect for sovereignty and territorial integrity, non-aggression, non-interference in each other's internal affairs, equality and mutual benefit, peaceful coexistence. The basic connotations with the 5 principles are as follows: the equality of states, the right to each state to safeguard its own interests and obligation not to infringe upon interests of others, reciprocity of rights and obligations, and the promotion of peaceful coexistence and common development. These elements are in line with the essential need for democracy, solidarity, and the constructive development of mutual relations in international community. And we think that the Chinese delegation's approach was seeking common ground while reserving differences enabled participating countries to find a common basis for bridging the gap and resulting in the final declaration of the conference. So I want to emphasize that what is the golden rule of the Bandung Conference? What is the golden rule in the Golden Book? I see if this is taking common ground and against the differences. Secondly, I would like to see that the Bandung spirit reflects the basic principles of international law, which are of vital significance. And one feature of Chinese study of international law is the significance we attach to the basic principles of international law. And just now we mentioned the soft laws, the declarations, the resolutions of the General Assembly. They are important because they reflect the very basic rule, like the golden rules that we mentioned. International law itself or its specific areas are characterized by a lack of words, the problem of fragmentation, the phenomenon of law without a clear text. Also, there are gaps between the lex lata and the lex ferenda. And there is no global government, no global parliament policy, and a lawmaker like a national framework. Then the general principles are quite important to guide the interpretation, the application of international law. In this sense, I see the 10 principles of the Bandung Conference is historically important. Today, we read them again, and we are proud of that. On the top is human rights. It's respect for fundamental human rights and for purposes and the principles of the UN Charter. So Asian, African countries, we also contribute a lot to global human rights promotion. And we already know that for drafting of the Universal Declaration of Human Rights, the Asian drafters also played their very important roles. And we know that after adoption of the 10 principles of Bandung Conference, there are several international law documents mentioned international principles, and they are consistent. Thirdly, I would like to emphasize that there is still a need for Asian countries to continue to pass on the spirit of Bandung Conference and to bear in mind the goal of building a community of shared destiny for mankind in order to advance the rule of law in Asia into a new era. I agree with the distinguished ambassador just now. He said the Bandung Conference is still relevant. It is. I see for the world is very much complex. Because it's complex, so the very simple, very basic golden rule is even more important. Today, Asia has become one of the most dynamic and promising regions in the world, with outstanding contributions toward economic development. And at the same time, Asia and the rest of the world have joined hands to deal with the traditional and non-traditional security threats and many other challenges. And China emphasizes that we are a member of the Asian family, and a member of Asia, China is linked to the common interests of all Asian countries, sharing the same philosophy and path, and its future and destiny are at stake. Chinese President Xi Jinping has put forward the important concept of building a community of shared destiny for mankind. So I want to say our country's position. China firmly upholds the international system of multilateralism with the UN at its core, and the international order based upon international law. It firmly opposes hegemonism, unilateralism, and protectionism, and promotes the development of the system of global governance in a more just and rational direction, with a view to build a community of shared destiny for mankind. Next, I would like to talk about Asia and human rights. We know that this year it's the 75th anniversary of the UN Universal Declaration of Human Rights. Since the end of last year, the UN High Commissioner for Human Rights initiated the movement titled Human Rights 75. And as well, this year marks the 30th anniversary of the Vienna Declaration and Action Program for Human Rights, adopted by the World Human Rights Conference. And according to the Vienna Declaration, all human rights should be considered as a whole. After the People's Republic of China was founded in 1949, the Chinese government repeatedly urged Western countries to put an end to colonial governance, racial discrimination, and Emperor Hadi. Now China advocates the comprehensive development of global governance of human rights. And we know that in the UN, there are three pillars: peace, development, and human rights. That's the mainstreaming of human rights. And inside China, there is also change of mainstreaming of human rights. I'm a member of the Committee Against Torture, and for my committee, this year marks 35th anniversary of its establishment. And in our continent, in Asia, there are several states still not state parties to this convention against torture. Totally, we have 173 state parties. You may know Singapore, Malaysia, India. They are not state parties yet. My understanding is that all of us, even the countries not a state party to the convention, we uphold the human rights values, the purposes. But for the international human rights mechanism, for the allocation, distribution of power between the states and international organizations, there may be different understanding. However, I believe that we have no objection to upholding the banner of human rights, values, purposes reflected by the human rights treaties. That is the very basis for our responses to the human rights issues. Beginning of this year, the High Commissioner for Human Rights, Mr. Turk, sent me this e-card for the new year, and you could see the background of the darkness. So that is the situation today. That is the human rights promotion, protection in the year. On 28 July, the High Commissioner for Human Rights held a meeting with the Committee Against Torture, and I expressed my opinion. I said there are two trends today. One is the holistic approach to human rights. All human rights should be considered as a whole. So today, torture is not a simple concept. It's an umbrella concept covering different types, different forms of violation of human rights, like domestic violence, trafficking, like the concerns about persons deprived of liberty in different places, like in hospitals and welfare institutions. So today, the definition of torture is quite different from before. The second trend is mainstreaming of human rights. So different organs of the UN, different international organizations, and the mainstreaming of human rights into their policies and implementation of their policies. And yeah, the High Commissioner said that today human rights protection is facing the challenges of polarization, politicalization, instrumentalization. And he said for any society, if torture is tolerated, there will not trust between people, and stability, prosperity. So we still need to uphold the very basic tenets of humanity. Torture and other ill treatment should not have a place in today's world. And I believe that our society will play our role for promotion of human rights, including to bridge different peoples, bridge countries, and the international organizations, the international human rights mechanisms. I want to say that we colleagues of Asian society or international law have a special responsibility to promote the Bandung spirit. We could work together to promote international law research, education, and practice to promote rule of law, peace, development, and human rights in Asia and the world. I thank you all.
Thank you very much, Prof. Liu, for very interesting presentations about the Bandung spirit and human rights. So we still have about 10 minutes, roughly. So I think I will give the opportunity for the floor to ask questions, just 2 questions from 2 different people, of course. And just give the direct question, so it will be no other presentations. So it's more a direct question. So please, anyone? Okay, one from here, and then maybe from the women.
Thank you very much for all your presentations. My name is Serhi Masol. I'm Humboldt postdoctoral fellow at the University of Cologne, Germany. Thank you very much for organizing and inviting me here. I'm very happy to be for the first time outside Europe. And my question is, in fact, to all of the panelists, because I think most of you, if not all, mentioned the Russian-Ukrainian war. And in light of the title or subtitle of the conference, the Bandung's period, do you think that one of the ways to reconstruct that spirit is to apply the general principles adopted at the final communique of the Bandung conference, specifically to some states that historically were not considered or were silenced in a way in light of their imperial ambitions, particularly the Russian Federation or the Soviet imperialist government? So the final communique of the Bandung conference was silent about Soviet imperialism, Russian Empire, and lots of lands in Asia. Russia remains the biggest country in Asia, were conquered by brutal force throughout 17th, 19th, 20th centuries. So the way to reconstruct it today in light of the atrocities in Ukraine is in fact to call Russia an imperial power. And not only Western powers can be imperial.
Okay, thank you very much. The next questions from, yes, please.
Thank you, Bang Hadi, for the opportunity. My question is to Ambassador Havas. My name is Putu Matthew Simbolon. I'm a junior trade lawyer in Bunjamin and Partners, the junior of Pak Eri Bunjamin. So my question to Ambassador Havas is concerning the unilateral action which conducted by EU, and I do, of course, with all due respect, have read your article concerning the EU DFR and the private data protection. So according to your opinion, do we need to solve this kind of unilateral action by just let's say, fighting the fire which caused by the European Green Deal and the Fit for 55, or shall the, let's say, Indonesia or other developing countries on the WTO shall have a collective will to solve this kind of unilateral action for the sake of environmental protection, yet somehow it is just meant to protect the European industry itself. I'm asking this question, of course, I mean, in the academic sense, so my apologies if it is a bit offensive because, again, only developed states such as United States and EU who conduct this type of unilateral action. Thank you.
Okay, thank you very much for the questions. I think we will start with anyone? Professor Orford?
Well, Professor Angie said one of the reasons you have Australians at a conference like this is because we're more blunt. So I'm going to be slightly blunt in my response, I think, to what you just asked, if you'll forgive me. But the question, I think, is from a European perspective about a European conflict at the Asian Society meeting is the best way to reconstruct the Bandung spirit for international law, to call out Asian states for not sufficiently involving themselves in relation to the Russian invasion of Ukraine. And I think that that's just a question that needs to be kind of thought about very carefully in the place in which we're sitting in this room. So I suppose my response would be that, as I said in my remarks, it's really important to look and think about why states and other actors in Asia, Africa, Latin America haven't taken quite the same response, at least not all of them, to the Russian invasion of Ukraine. Of course, many states have, and I also, and other actors, and I noted some of those. But whether all states then have some obligation to involve themselves in that conflict, I think is a really complicated question. And partly it's complicated because I think we've been for a long time, I don't think we've escaped a world of imperial powers, in fact. I think we talk about sovereign equality. Bandung is all about sovereign equality, not intervention, self-determination. But there are states and then there are great powers, and those great powers try to constitute regional orders, and if we're allied with them, we'll go along with it and create an account through international law that gives meaning to that regional ordering. And if they're our opponents, then we'll take a different position. So I've written a piece on regional orders that came out in the Current Legal Problems series, and I would, I suppose, say that my longer answer to this question comes from that. I think it's absolutely vital at this moment, indeed, that states take positions against aggression, against occupation, against genocide. Absolutely agree. And I think that has to be consistent, and in relation to my own country, I think that's really important. But I also think it's a very complicated thing to kind of to ask that question here in a context where this is what we're discussing. There's one other point I really need to make, and I'm sorry, I should have made it in opening, and I'm just going to say it officially. So just, you mentioned in opening that I'm a visiting legal fellow at DFAT, our Department of Foreign Affairs and Trade. Let me just say the thing I should have said to begin with. I need to make clear that any views and opinions I express in my lecture and my answers to questions don't necessarily reflect the views or opinions of the Australian government or the department.
Thank you. Professor Liu, do you want?
It's a very good question. It's a question for not only for us, it's for all of us. Actually, as I said, today the situation is dangerous, uncertain, as the situation in beginning of 1950s, and even more dangerous than that at that time. So whether there is a risk of a third world war is a serious question. And there is no, I want to say, there is no country totally correct or totally wrong. And we seriously need to review why the conflict occurred and is occurring, and how to end it, what is the future, and how to review that. And I see the Bandung conference spirit, the golden rule written in the golden book is quite basic, quite simple, but quite basic. If there is no mutual trust, mutual interest, if there is no shared destiny, and if there is some country put their own national interests above other nations, it's quite dangerous. I remember that the great Indian philosopher Tagore, he wrote a book, Nationalism. He discussed this before the Second World War. He warned international society to respect different cultures, different interests of different countries, but he failed. The Second World War occurred. And then it seems something is repeated. So today, seriously, we need international law. We need the wisdom of international law, and we need the golden rule of Bandung conference. Thank you.
Thank you very much, Prof. Liu. Ambassador Havas?
Yeah, thank you very much for the questions. If you recall, before 1960, the law of the sea at that time was basically a heritage of the colonial power. So the developing countries of Asia, Africa were not yet independent when law of the sea was made up to 1958. And many of them were still new countries, newborn countries who have nothing to say, on the governance of the oceans. And after that, in the 60s, different developing countries demanded better rights and responsibilities and governance of the oceans, and thus and therefore you have a very long discussions and negotiation in Geneva all the way to 1982. So the takeout is that developing countries, Asia, Africa, can actually change international law. And many international law that came after that had a lot of says from developing countries. Human rights conventions, for instance, right of the child. For instance, I was involved in the negotiations itself, and different types of negotiations after that. And similar thing, I believe, should be done in terms of international trade. Look at the case that we have today. We banned the export of nickel, raw nickel, because we want to create value-added economy for our own people. We want to create a wealth for Indonesian people. When we export the raw materials, nickels, abroad from 2005 until 2019, we only receive somewhere around $1 billion every year of our export, and no jobs created, no education created, no value added created whatsoever. So when we ban the export of raw materials, we created 80,000 jobs in the smelter industry, there are now a couple of vocational schools on material technology. There are now a number of schools sprouting around the area of these smelters. We are now having a clear reduction of poverty in the area where the industry of nickels are there. And if you look at the different stories, say in Africa, there is a very interesting video from reporting from Deutsche Welle about cobalt mining in DRC. There are 17 international miners in DRC. If you look at the case in Africa, the raw material was extracted, they cleaned with water, and then the water was just dumped. Okay, the local population had no access to health today, no jobs created. You have just illegal mines everywhere, and the raw material was just taken and exported somewhere else. And the smelter and the downstream and the technology is created somewhere else. So what do the African countries get out of these minerals, raw materials? So far, as I see, nothing. So when we ban the export of raw materials, and the reaction of EU is such, so it comes to a conclusion that raw materials is, of course, is very critical to the future, and that is why the national interest or regional interest for country of origin to develop itself is not there. As a matter of fact, the international law existing today, WTO, actually side on the thinking that you should not develop your own country in the raw materials, because by law you should not ban it. So whether or not we create jobs, WTO really doesn't care. Whether or not we able to create schools, WTO doesn't really care. And this is, I think, similar to situations of Lao Tse before 1960. So the task is just to change the law, like what we changed Law Tse before 1960. Now, whether or not countries in Asia, Africa are up to this mammoth task, I have no idea. But there is no other way. And I've been speaking to German industries, European industries. Some of them actually understand our positions. And some of them actually says that, well, Ambassador, if that is the case, then either you change the WTO law, or you create an alliance of raw material producing countries. And the purpose of the alliance is to create a grouping where you can introduce your interest into a proper legal arrangement. But this is going to be a very tough battle, because of course the interest of the user of raw materials, which they don't have it, will be completely against it. And again, I did not follow when that this UN resolutions on the sovereignty of natural resources suddenly is gone along the way. I don't know when it happened and where it happened, but Asia Africa lost it. We lost it. We lost the battle of our own natural resources sovereignty somewhere along the line, and now we cannot even process our own materials. So I think this is like deja vu. Going back when the Dutch came to Indonesia and took all the spices and sell it to Europe. Same thing. There's no difference. So that is why my article in Jakarta was a little bit tough. And, I think it's not tough. I think it represents what is reality today. That it is actually recycled of what happened in the past 500 years ago, where Europe came, extract raw materials, send it to Europe. Same thing, whether it's spices, clove, nickel, cobalt, rare earth, same thing. The only way for us is to unite the mind and thinking, and hopefully we can come up with some internationally acceptable, more balanced, approach on this particular issue. At least this position is not coming just from me or from Indonesian government, some German industries, some European industries, the big ones, they actually understand this importance of raw materials being processed in the country of origin. So the fact that some bureaucracies in EU simply disregard it, that I am lost, because that would, I think, again, different types of this campaign that they're saying about of the developing countries. So, yeah, task is very future.
Thank you, Ambassador Havas, for the answers. And then the closing will be given to Professor Luis.
Thank you, and thanks for the answers of my co-panelists. I don't have much to say. I think we all need a coffee. Just as a teacher of international law, what I can say in front of in response to the two questions is that if we take Bandung seriously, one lesson that comes out clearly is that there is no one international law. I mean, there is no such a thing as an international law that stays up above in the skies and it is untouchable. Part of the spirit of Bandung is this idea that rather than international law being one and then progresses in a linear fashion, as I try to suggest, it is a, you know, international law is mined by constant dialectics where different interests are constantly at play, and the emphasis of Bandung is on the interests of those that have not usually been heard or have been easily sidelined, and that requires sometimes taking common decisions and forming common blocks and regional interests. Sometimes it could be a moment of accepting that national self-determination and sovereignty and having our own governments implies different positions in relation to the international legal order. And I think we just heard a very clear expression of that and how the Bandung experience in relation to the EU actions against Indonesia should be read not as a ratification of Indonesia not following WTO rules, but rather than Indonesia has a right to oppose to an agreement that goes against the most fundamental developmental rights of Indonesia. And I think it's once again, it's a clear materialization of what we here celebrating and as the Bandung spirit.
Thank you very much. So this will be the end of the plenary panel, and please give applause for the outstanding panelists that we have today. And before I end this panel, I have announcements that ASEAN SEAL Interest Group will be held tomorrow during lunchtime, and then tomorrow morning the venue will be announced, and then there's several Asian SEAL Interest Group that you can join. There is an interest group on human rights, law of the sea, environment, history, and theory, and others interest group that you can join tomorrow during the lunch. So that's the announcements for tomorrow, and I hope you enjoy these discussions, and I learned so much about it and give me quite a lot of idea, especially for my articles journal. So thank you very much and have a good day.